Hello everyone, welcome to Learn Law with AKP. In today's session, we are going to discuss an important topic under contract of guarantee, discharge of surety. In earlier classes, we understood the rights and liabilities of a surety. Now, the important question is, when does the liability of the surety come to an end? The answer is explained under the concept of discharge of surety. This is a very important exam topic, especially for long answers and problem questions. So let's begin. First, let's understand the meaning of discharge of surety. Discharge means release. So, discharge of surety means the surety is released from his liability. After discharge, the surety is no longer legally responsible for the debt or obligation. For example, suppose a guarantor was responsible for a loan. If law releases him from liability, then he is discharged. So, discharge means ending of liability. Now, let's understand the different modes or methods by which a surety may be discharged. A surety can be discharged by revocation of guarantee, by variance in terms of contract, by release of principal debtor, by acts or omissions of creditor, by loss of security. These are the important ways recognized under law. Now, let us understand each one clearly. First is discharge by revocation. A continuing guarantee can be revoked by giving notice. But this revocation affects only future transactions. Past transactions remain valid. Suppose, for example, B guarantees future purchases made by A. Later, B cancels the guarantee. Now, B is not liable for future purchases but remains liable for old transactions. So, revocation works prospectively. Now, let's understand discharge by variance in contract. Variance means change in terms of contract. If the creditor and principal debtor change the contract terms without consent of the surety, then the surety is discharged. Example, suppose guarantee was given for repayment within 1 year. Later, bank and debtor change repayment period without informing surety. The surety may be discharged. Why? Because the contract originally guaranteed has changed. Another important mode is discharge by release of principal debtor. If the creditor releases the principal debtor from liability, then the surety is also discharged. Example, if bank legally forgives borrower's debt, then the guarantor also gets discharged because there is no longer any debt to guarantee. This is a very important principle. Now, let's understand discharge due to acts or omissions of creditor. If the creditor does something which harms the rights of the surety, then the surety may be discharged. Example, suppose creditor negligently allows security documents to be lost. This affects the surety's recovery rights. Therefore, the surety can be discharged. Law protects the surety from unfair conduct. Another important mode is discharge by loss of security. If the creditor losses or parts with the security held against the debtor, the surety is discharged to that extent. Example, suppose bank had gold security but lost it carelessly. Now the surety loses protection. So law reduces or removes surety liability to that extent. This rule protects the surety. Now let's understand an important case law. In Home versus Brunskill, a guarantee was given based on certain contract terms. Later, the creditor and debtor changed the contract terms without consent of the surety. The court held that the surety was discharged. Here, the principle established any material change in the contract without consent of surety discharges the surety. This case is very important for understanding variance in contract. Now let's quickly revise the important modes of discharge. A surety may be discharged by revocation, by variance in contract, by release of debtor, by creditor's acts or omissions, by loss of security. These are extremely important for exams. Let's conclude this topic. Discharge of surety means release of the surety from legal liability. The Indian Contract Act provides several protections to sureties. A surety may be discharged due to revocation, change in contract terms, release of debtors, acts of creditor, or loss of securities. We also understood these principles through the case of Home vs. Brunskill. So remember, law protects sureties from unfair liability. For exams, always remember modes of discharge, examples, and case law. Thank you. If you found this video helpful, please like, share, and subscribe to Learn Law with AKP. Stay tuned for more law topics.